David Camp. I represent Mr. Barker in relation to the matter before the court. At this time, with the court's approval, I'd ask for 5 minutes for rebuttal time.
Okay.
The case before the court, as the court's read through the brief itself, is rather somewhat straightforward in many respects, and actually is more of an evidentiary type issue that I think the court's confronted with today, more so than anything else, but ties into some fairly significant and important points that I believe need to be made out as to the error that was committed by the trial court in this matter. The factual basis of this is fairly straightforward. It is alleged that in July of 2016, my client, Mr. Justin Barker, allegedly had sexual intercourse with a underage female occurring in Henry County, Tennessee. Now, what is also of note as well, that although that event was alleged to have occurred on July 6th, or July 4th or 5th of 2016, it was actually three subsequent sexual encounters that occurred as well with the same female with Mr. Barker are alleged to have taken place, but that occurred in Gibson County, Tennessee, an entirely different judicial district, as the court's aware. And in relation to those subsequent sexual encounters that occurred, it was alleged by, again, the same female, and we'll refer to her initials as LW, that my client had sexual relations with her, one in a swimming pool in Gibson County, Tennessee, some few days after this incident is alleged to have occurred on July the 4th of 2016. And then again in 2017, there were two additional separate encounters that occurred, but they occurred in what would be referred to as the grandmother's home, Miss Carolyn Stewart, again, subsequent to the allegations that there was a rape that occurred on July the 4th of 2016. Both of those incidents occurred as well in Gibson County. What it came down to was this. It was a trial strategy that was pursued after a great deal of consideration and thought as to whether to bring up the allegations that had been raised by LW concerning the Gibson County incidents, although they were technically subsequent to what occurred in Henry County. So in effort to impeach LW, it became necessary to raise those issues that she brought up, primarily because of statements that she had made arising from what she claimed was the rape that occurred in Henry County, Tennessee, on July 4th of 2016. So to understand the facts of that, here's what occurred. According to LW's testimony, she rode with both my client, his 3-year-old daughter, or 2-year-old daughter at the time, her grandparents, well, that was the 5 of them in one vehicle, and they rode up to Henry County, Tennessee, to the river to celebrate the July 4th holiday. They were staying in what I would clarify as a modified cabin or a trailer that was extremely small. Allegedly, during the night, my client, LW, went and left the facility that they were staying in. She alleges that the rape occurred while they were out walking somewhere around the facility or the perimeter of the river, and then went back in the house, went to sleep, stayed for that day, then rode back that night. No statement, assertion, or claim was ever made by LW that any such rape ever occurred or any such sexual encounter ever occurred. So as a result of that, for over 2 years, there was no complaint made, no claim made, no allegations made, no assertions made of any rape having occurred. As a result, there's no physical evidence that any sexual encounter ever occurred. This came down to, quite frankly, a he said, she said argument. That she was saying he had sex with her. He was saying, of course, through his not guilty plea, he did not have sex with her. And so as a result, credibility became the key issue. At the beginning of the trial, the state raised what was called a Rule 412 objection because the state was fully aware that under the circumstances we were going to raise, as part of our cross-examination, these subsequent sexual encounters. And the theory was very simple. If she, in fact, were terrified of him, as she said she was, if, in fact, he had forced her, as she said he did, or coerced her, as she said he did, or if he had had sex with her without her consent, which was count 2 of the charges, then she continued to keep coming around him, kept being around him, did not run from him, did not hide from him, and yet had 3 sexual encounters subsequent to that, which occurred in what would be considered very physical impossibilities. One rape was supposed to have occurred in a swimming pool. 2 rapes occurred in a house when she was supposedly left alone with him by her own choice. So these were facts that we thought were pertinent and relevant to bring up to question whether or not she truly, in fact, had a sexual encounter with him in July of 16, and also to come up with whether or not she actually feared him as she claimed she did. The problem that came up is the court did a jury out hearing on the 412 determination. The state was arguing that there should have been notice given of the allegations that there was going to be sexual interaction between, or there were going to be allegations there was sexual activity on the part of the rape victim. The court found in behalf of the defendant that we were using it for impeachment purposes only to raise questions of credibility and issues regarding fact that we wanted the jury to hear. Where the problem became is when L.W. took the witness stand and was on redirect examination by the state, they then brought out the fact that my client had been criminally charged in Gibson County on these 3 separate sexual encounters.
Doesn't that go to her credibility as well, though?
No, and I would and I don't mean to say that in a disrespectful way, Judge Dyer. No, it would not, because the question is not whether or not he was actually criminally charged and whether there's some bolstering of her credibility, which I guess is what they were attempting to try to do with that. The key is that it still brought out there were criminal charges pending, which would have been obviously adverse to my client's interest.
But your questioning of the victim makes it sound like it was a consensual, which is, I understand, makes it sound like it was these other events were consensual. If they occurred, they were consensual. Which, to show that maybe that she wasn't scared and that the first events either didn't occur or were consensual as well. So if charges were filed in the second group, that goes to her credibility as far as whether these are consensual acts or not.
Well, it wasn't solely for the issue of consent. Our position was there was no sex.
Right, but either way.
There was a young lady, and I will say this, and I put this in the brief for the court's review, and I think it cites it well into the record. Harley Henderson is a woman that he started dating sometime in late 2017. During her testimony, she said that after the incident occurred in July of 16, mind you, he didn't even know her in July of 16. Supposedly, she said that Mr. Barker told her that if you tell anybody I did this, I'll just say you're jealous of my relationship with Harley Henderson. Now, there's no way he could have said that because at that point in time, he didn't even know who Harley Henderson was, yet that was her testimony. It went to her credibility. That also went to the proof that she also made separate allegations, again, preceding him dating Harley Henderson. Carolyn Stewart, the grandmother, testified that she saw a marked change in L.W.'s behavior after he started dating this young lady. And this was in the fall of 2017. So the defense was, to some extent, there was some jealousy aspect on her part. Now, whether she perceived there was a relationship or whether there was a relationship is really beside the point. The fact is it gave her motivation to lie, and it showed that she, in fact, did lie.
Which is an argument you made to the jury.
Absolutely, 100% that was made to the jury. But
the jury also has the right to know the entire story, do they not? Within limits, obviously, and that's my next question, is how did the trial court limit at all this information with an instruction?
I'm sorry, Judge Dyer.
How did the judge limit the second, and I'm going to Crockett and Gibson, I can't remember which one, but how did he limit the second round, this other criminal act? Did he limit it with an instruction to the jury?
He did, and he actually talked about that in the jury charge. The government raised it in its brief, was to say that basically if you find the discrepancy was of a material nature, you could raise that issue at that point, all of it collectively taken into consideration.
Well, no, what I mean is, did he tell the jury you can't consider these other acts as, you're not determining guilt or innocent on these other acts, and they can't go to whether or not he committed this act? It's all about credibility?
Thank you, Judge. The answer is yes. He gave that instruction to the jury, but the problem we have is very simple. It should have never been brought up in the first place. That's a 404B issue that the state has an obligation to put on notice if they're going to use it as to actual criminal charges. It was never brought in for the purpose of determining in this case as to whether or not he was charged or not. It had to do with whether or not you can believe what she had to say about subsequent incidences and the manner in which those occurred. The fact that he was or was not charged in Gibson County was not pertinent for the jury to know. First of all, it was not relevant. Second of all, there's a best evidence rule because they never introduced any of the documents pertaining to the actual charges. Third, it was a hearsay question because the only one that testified about whether or not there were charges is L.W., and the only way L.W. found out about it is if she was told about it.
Mr. Camp?
Yes, sir.
Was she, I guess, impeached or attempted to be impeached by you with statements from the actual hearings, the preliminary hearings?
That is correct. Actually, we used those as to prior testimony that she had elicited, but not per se as to actual preliminary hearings within the prosecution in Gibson County or the prosecution in Henry County. She gave 2 separate testimonies, one in the preliminary hearing in Gibson, one in the preliminary hearing in Henry County. And her testimony was pretty much the same as it related to the incidents that occurred in both.
So the initial, I guess, the other acts in the other counties, the substance of those were brought up, but she was actually presented with her testimony. And that's the state's argument, really, that to complete the picture, where did this testimony come from? Is it in a vacuum? Were those charges dismissed? That's their argument. But you actually impeached her with what she said in court, right?
Right, Judge Wilson, that's correct. What it came down to is when she testified in Henry County, I can't recall the timing on it, if she had already testified in Gibson County or not, but the incidences were raised in both counties at the preliminary hearing stage. So that when I say there was no difference in it, it meant there was no difference in what she was questioned about. There was significant difference in what she had to say about the events that took place in Gibson County when she testified in Gibson County versus what she said about Gibson County when she testified in Henry County. So those were the impeachment aspects of this, just the complete and total discrepancies that she gave as to the events that occurred and how they occurred. That's why it was so pertinent to bring it up in the trial, but not to bring it up for the purpose of informing the jury he'd been formally and criminally charged in this other county. That's not why that was presented. And I would submit that if you're introducing this proof for impeachment purposes only, it doesn't open the door for you to come in as a state and start saying, but he's been criminally charged. I'm not sure how that's even remotely relevant to the proceedings that were in front of
If your argument is she's not telling the truth,
Right.
and that either it didn't occur or these are consensual acts, then is it not relevant that there are charges pending for similar acts against her by him somewhere else?
Let's go this route if we can, Judge Dyer. I would say no, it's not relevant, primarily because it doesn't go...
Relevant only to credibility.
But I guess the question I raised at the time with Judge Parrish, and I raise this again now, I'm not sure how that in any way addresses credibility because they chose to charge him because she's telling them the same thing she said in Henry County based on separate instances. Secondly, even if it is relevant for purposes of our argument today, there is still a 403 issue you've got to address. What is the prejudicial effect, and does it in fact outweigh, substantially outweigh, or is it substantially outweighed by the probative values? The court's well aware of Rule 403. I see no way it can pass the 403 muster, and I would submit to the court even goes as further to 404B, and in this instance, they did not follow the protocol or procedure necessary under 404B. Now, I found the state's argument somewhat interesting because the state's argument tended to say, well, yeah, there was a 404B analysis through the 412 analysis.
That was going to be my next question.
But it wasn't.
So at the 412 hearing when the state loses,
Right.
is there any mention during that hearing that, well, if we lose, since we've lost, we're going to bring this other stuff up then to counteract this? Or was it just silent on the Gibson County stuff until you actually questioned her about it?
Well, actually, the way it worked, and that's a good point, Judge Dyer, the way it worked is this. The 404B analogy, if you call it that, and it was never referenced as 404B by Judge Parrish, was 100% about what impact effect or what was it going to do to the rape victim, because that's what 412 is all about. It had nothing to do with what impact effect it's going to have on the defendant. That's not what the 412 hearing was about, and that's where the analysis was. And in fact, LW had to testify in the jury out hearing about all of that. So we fast forward now to the redirect.
So the state never mentioned at the 412, I want to make sure I understand it. The state never mentioned at the 412 hearing, since we've lost our motion, we're going to bring this up if he opens the door.
That's correct.
Okay.
Never got brought up. It got brought up on redirect of LW after it was brought up on cross.
Right.
It was never brought up even through their direct testimony. That's where I would argue to the court, that's when it was improper to have allowed that in. Any even reference to criminal charges. They could have gone in and tried to rehabilitate her and say, okay, tell me about this. All these incidents took place. It was an unusual strategy, and I will grant you that, but because the discrepancies were so extreme, it was one that, quite frankly, I don't think we had any other alternative but to pursue that, and I don't think we were expecting criminal charges to come out. Again, and I would say this, Judge Dyer, in one closing note, and I'll reserve my 5 minutes. Again, the problem is this. If you're going to introduce those pending charges against him, you need to bring those charges in, and that was never done. And so even if you accept everything else, they tried to bring it in through the wrong witness. They should have brought in the investigator from Gibson County. Some sort of indicia of reliability as to any of the issues. Otherwise, you just got it hanging out there. And that's the problem with trying to defend it under those circumstances. That's not the purpose for which it was originally intended. Thank you.
May it please the court, Brent Cherry for the state. L.W. was 9 years old when she first met the defendant in 2011. Her mother was dating the defendant's uncle, Kevin Wright, and 2 years later, in 2013, L.W.'s mother and Mr. Wright got married, and the family took up residence in a house next door to Mr. Wright's parents in Gibson County. At some time after 2013, the defendant moved in next door with his grandparents. And on the 4th of July weekend in 2016, when L.W. was 13, she went with her grandparents, I guess is probably the best way to describe them, and the defendant and the defendant's 3-year-old daughter to the river in Henry County, where the grandparents had a house. At the time, the defendant was 26 years old. When this case went to trial in January of 2022, L.W. was 19. She testified that on the 4th of July weekend in 2016 at that house on the river in Henry County, the defendant raped her. L.W. testified about the circumstances, going for a walk with the defendant that night, defendant talking to her about sexual matters, and how the defendant started brushing up against her and ultimately pushed her up against a tree, pulled down her pants, and forced his penis into her vagina. The rape was not reported until January of 2018. Now, the defendant argues that the trial court erred when it allowed the state to introduce testimony relating to pending charges filed against the defendant in another judicial district when said charges involved similar allegations and the same alleged victim. Here, however, Judge Parrish properly allowed L.W. to testify that charges were pending against the defendant in Gibson County based on her allegation that the defendant raped her on 3 separate occasions subsequent to the rape on the 4th of July weekend in 2016. This was an unusual case where prior to trial the defense requested that the court allow the defendant to question L.W. about her subsequent rapes in an effort to challenge her credibility and discredit her trial testimony. The defendant does not challenge the trial court's decision to allow the defendant to question L.W. about the other rapes. Instead, he argues that the trial court erred when it allowed the state to introduce testimony of pending charges against the defendant in another judicial district because it was irrelevant. But on multiple occasions during the defense cross-examination of L.W., the defense referred to L.W.'s prior testimony about the other rapes in other proceedings. The defense challenged L.W.'s trial testimony or hearing testimony about the rape in the swimming pool behind her mother's house a few weeks after the first rape, and referred to a transcript from the proceeding in Gibson County that was conducted on May 9th, 2018. The defense referred to Gibson County proceedings again when it questioned L.W. about the rape in the spring of 2017. Quote, "So, did you just forget when you testified about this on May 9th of 2018, unquote. After the defense cross-examined L.W., the state asked on redirect examination whether she knew if rape charges had been brought against the defendant in Gibson County, and the defendant objected, arguing that whether charges had been brought was irrelevant and beyond the scope of cross-examination. And the state countered that if the jury were left unaware that charges had been brought against the defendant, quote, they could be in a position of thinking, well, the state and law enforcement doesn't believe these other instances, and so nothing has ever been pursued about them, and that would undermine the credibility of this victim here, unquote. So we are still talking about the credibility of this victim and how it's being attacked, and is it fair to allow at least her impression or her understanding of what's happening in these other proceedings?
How do you respond to the defense argument that there was no 404B hearing?
Well, Your Honor, there was a 412 hearing where essentially the process of 404B was followed. They addressed the issues of this other evidence, whether it was properly would be properly brought before the court, and although it was not labeled as a 404B hearing, and I've laid out in my brief essentially how that played out and how that process met the requirements of 404B. But the defense isn't really arguing that there wasn't proper notice, or that this evidence should not have been allowed as far as these other instances of misconduct. In fact, they've
his
invited
argument
this.
is that the trial judge, which would have been correct under 412, was looking at the evidence from the perspective of the victim. But a 404B would be looking at the evidence from the perspective of the defendant, and those are two different things.
They certainly are, Your Honor, but here...
So you got to weigh it against the defendant and not necessarily weigh it for or against the victim, which is what 412 does. So where did the trial judge weigh the probative value and the unfair prejudice towards the defendant as he would in a 404B hearing?
Well, Your Honor, and that's what makes this case so unusual. I think if this had been something where the state came in and said, we want to present this, and the defense had said, no, this shouldn't come in because this is other misconduct that should not be considered, I think that would have been a valid argument. But here is a case where the defense is inviting the court to allow this evidence to come in. We're talking about the evidence of misconduct, the statements or the testimony even of the victim in this case about what happened on these subsequent occasions. So when the defendant is not only standing back and allowing this, but actively promoting the admission of this testimony, albeit for the purposes of challenging the defendant or the victim's credibility, I think it's very unfair for He's not promoting the criminal charges, he's just promoting that she's told different stories. Those are two different things. Well, Your Honor, the allegations are, and I will argue that the allegations that were made initially and that were testified to in court and in the proceedings in Gibson County are substantially consistent, and that it was a bold thing for the defense to try to argue that, hey, I want to bring this in for purposes of challenging credibility, when these are allegations of other misconduct. I mean, that's obvious what these are. And when you get to the issue of, well, what's the current status of this case, there are a couple of things that the court would consider here. First of all, I mean, does this fill in the blanks for the picture or for the story that's being given to the jury to understand everything that's happening here? And I would argue, yes, it certainly does fill in the blanks in that picture, because as the state was arguing to the court, without this, you're wondering, well, what's going on? What is the status? Why, or is something else happening in this case? We know that something's happening because when the defense has cross-examined the victim here, they're asking her about her testimony in Gibson County, her prior allegations made in a formal proceeding. It's pretty obvious, based on that this defendant is facing charges in another jurisdiction. And that's been brought in at the invitation of the defendant. He's the one that's asked the victim about these other charges, about the other proceedings, and about her statements that she made before the court in that proceeding.
Is he asking about charges, or is he just, I mean, you can ask the questions he asks. I mean, again, we haven't read the record, so from what's in the briefs, he's just asking about proceedings, which doesn't necessarily mean that there are charges pending. I mean...
Well, I think that's...
And you have to admit that in a rape case, bringing up other charges in another jurisdiction of rape are prejudicial to a defendant.
It would be, Your Honor, except in this case, the defendant wants it brought up. He wants those accusations.
It's still prejudicial. Whether he wants it brought up or not, it's still prejudicial.
But I think there's a waiver argument or a strategy argument there, Your Honor. And the strategy here, whether we may or may not agree with it, is that the defense said, hey, let's look at your allegations you've made about these other rapes. And if you're going to go there, then it's only fair to say, okay, well, what's going on with these? What's the current status? Now, if he had been convicted already, that would have been a lot bigger issue. That would certainly be prejudicial. But here, the fact that these other allegations are being considered in another jurisdiction are neither exonerating nor damning.
Well, that was my question. Show me the difference between this and a situation where you have a defendant who's previously been on trial for perhaps the same allegations, the same charges, and then the victim or a witness is impeached by their prior testimony. You couldn't get into, he was convicted in that first case that we're here about, right? You'll admit to that, I mean.
Right.
Okay. So really, how is the fact there are pending charges in Gibson County different from the scenario I gave you?
Well, Your Honor, I think if, I mean, the first scenario that you're suggesting is kind of a different situation, and whether a person has been tried for the same act in another proceeding, I mean, are we talking about a situation where that case has been overturned, or in that case, you wouldn't have a conviction at all, but we've still got testimony that's being considered for purposes of impeachment. So this case is different in that no determination of guilt or and I hesitate to call it innocence in a court case because it's not innocent, it's being found not guilty. But whether another jurisdiction has found somebody guilty or not guilty, it could be relevant, but is it unfair? Well, I think we would agree that that probably is kind of unfair when we're talking about what's happened in this case, and then we look at his being convicted in another case, where the defendant has come in and said, I want to look at these allegations as they were presented in this other proceeding. The fact that no final resolution is out there for this proceeding is again, neither damning nor exonerating.
Well,
It simply says that this is out there.
We'll find it in the record, but how exactly did Mr. Camp present it to the witness, to the victim? Was it referred to generally like there was another proceeding in Gibson County in a sanitized fashion, or were the criminal charges, anything suggesting criminal charges alluded to in his questioning?
I don't know that there was anything specifically saying that he was charged in Gibson County, but the way it came out was, do you recall your testimony when you testified in Gibson County that the defendant did this, or as far as this allegation is concerned, this is what you said in Gibson County, and what do you say now? So the clear implication is that something was happening in Gibson County, that there was a formal proceeding, and that the witness, the victim, had testified at that formal proceeding, and obviously
that be a civil
the defendant was
proceeding?
a subject. I'm sorry.
Why couldn't that be a civil proceeding?
I suppose it could be a civil proceeding, Your
Why do
Honor.
we need to make it, why do we need to let the jury know it's a criminal proceeding?
Well, I think it's pretty unusual for a rape case to be a civil proceeding. I mean, it happens, of course. You could sue somebody for something that they've done in the past in a civil proceeding, but I think that's not typical. I think the clear assumption would be that if somebody's testifying about his rape in another proceeding in Gibson County, I think the obvious implication is it's a criminal matter. But again, you know, the court allowed LW to testify and answer questions about what was going on in this other proceeding as far as she knew. And as far as the prejudice is concerned there, I suggest that it's minimal. First of all, because there was no conviction. The simple fact is that this was something that was pending. And it's obvious that it was pending basically because she was testifying that, yeah, I did testify in this proceeding, something is going on. So the jury is obviously left with the understanding that something is going on in this case in Gibson County. Has he been charged? Well, you wouldn't be going forward with these kind of proceedings unless he was. What's the current status? And again, it's a pending case. It hasn't gone to a full criminal proceeding. So I would offer up that the prejudice here is minimal. I mean, if there's prejudice, it was brought on already when the defendant wanted to go there to cross-examine LW about her testimony and got into the actual allegations of these 3 other rapes. You know, really what we're talking about in this case my esteemed opponent indicated this was a he said, she said kind of a case. And it's not unusual to see these kinds of cases in allegations of rape, especially when they're reported at some point, after months or sometimes even years after the incident has occurred. But that's something for the jury to hear and determine. They're the ones that see these witnesses on the stand. They hear them, they see their demeanor, and they measure their credibility and determine whether this is something that rises to a level of beyond a reasonable doubt to support the allegations that have been raised. And that's what happened in this case. Now, the fact that LW was able to talk about the current status again is neither here nor there. It really doesn't hurt, nor does it help the defendant to say, well, these allegations have been raised and this is pending. So what? What does that tell them, the jury? That nobody knows where this case is going in Gibson County because it's just pending. The jury in Gibson County is going to have to do the same thing that's happening in Henry County. They're going to have to measure the credibility of this victim. They're going to have to determine whether she's telling the truth. They're going to have to determine whether this rape occurred or not.
So is it the state's argument that the defendant opened the door through bringing out these specific instances and the pending charges aspect that was brought out on redirect, that just completes the story on that? Is that it?
Exactly, yes.
And if that is true, is it really 404B?
I mean, we could, and again, I would, as I've laid out in my brief, I think the court went through basically a 404B analysis, but that, again, is something that the defendant has to protect himself, and he's pretty much tossed that out the window when he's invited this evidence to come in.
So through inviting this evidence to come in, your argument is he brought it up and this completes the story. It's not really 404B.
It doesn't really get to 404B, no, Your Honor.
Okay.
This was a bold move by the defense, and I got to give them, I think they deserve a lot of credit for being so bold. Now, whether it was a good idea, looking back to my days as a defense counsel, I don't know if I would have wanted to take that approach because it is very dangerous, and it does invite evidence of uncharged or not uncharged misconduct. This was charged in another jurisdiction. So it's from another realm, if you will. But this was brought on by the defendant himself. He invited this. He wanted this to come out. And the simple fact now that he's arguing, well, wait a minute, you can talk about your allegation and what you say he did, but don't tell the jury that something is still hanging out there, that something could still be coming down the road. Not that this is a conviction, but this is pending. And there's a big difference in those two. So I think the court acted properly in allowing the state to kind of fill in some of these blanks. And I would encourage the court to affirm this judgment. There's been an argument raised about sufficiency, and I'll rely on my brief, as that's not been brought up today in oral argument.
Thank you, Mr. Chair.
Thank you.
Mr. Camp, you have your rebuttal time.
Thank you, Judge.
While you're walking up here, let me post a question to you.
Yes, sir.
Goes back to what Judge Wilson asked.
Sure.
Your questioning of the victim was sanitized in the sense that you didn't refer to criminal charges.
Right.
You just asked about statements she made in a proceeding.
Right. And the proper way that I understand to conduct that cross would have been to have said on such and such date, you testified so-and-so, because you have to be able to bring out a prior sworn statement.
Right.
And to identify and make sure you direct the witness's attention to when that statement would have been made in order that it's clear on the record and it's clear on what that witness had said. And that was the discrepancy sought were the discrepancy between that testimony, the testimony during the preliminary hearing in Henry County, and then obviously what she was testifying to at this trial. And on page 11 of the brief, as I've identified for the court, and this may help to clear things up a bit, and in the middle part of that, quote unquote, LW testified that the alleged rape in Paris caused her to fear Barker and that she was terrified of him. This was during the trial. Subsequent to that, LW testified that she was always afraid of him because of what he did to her, creating that fear factor and trying to assert that there was a rape that had occurred. And again, this is 100%. She said he did it, and he said I didn't do it. There was no other evidence supporting that there ever was sexual encounter that occurred. Then I go on to identify for the court the 3 separate incidences which occurred subsequent to this allegation that a rape happened. And the first sexual encounter was 3 weeks following the incident in Paris. Now, she's supposed to be so afraid of him that he comes over to her while she's swimming in the swimming pool. She doesn't get up. She doesn't leave. He's got his daughter with her, and she's jumping off a diving board, and she's 2, while he's raping her in the shallow end of the pool, according to her. So this is a credibility question about why would she have had this interaction with him such a short time period from after she claims this rape had allegedly occurred in Paris. In addition to that, subsequent as well, she voluntarily goes over to the house where he's living and leaves herself alone with him on 2 more occasions, although she's terrified of him. And on the 3rd occasion, she even removed her own clothing and testified to that. It wasn't a forcible issue at all. She just simply had a relationship with him according to her. These are factual issues brought up. They're not brought up for the purpose of being able to introduce the fact he has been criminally charged, because there has been no determination made on that. And that, as the court has pointed out, I think rightfully so, is extremely prejudicial. Now, all of a sudden, the jury's made aware there are criminal charges pending in another jurisdiction for allegations that have been made, and that is not what the purpose of this being brought into in the first place was. The state was clearly aware of it because they raised the 412 objection before this trial even began. They knew this question about her sexual interaction with him subsequent to this was going to come up, which then leads to the question of if the state was then going to counter that with wanting to introduce criminal charges. I believe under those circumstances there should have been a 404B analogy done, and if anything, the state could have done it at the time that the court was undergoing the 412 analysis. When Judge Parrish said, we're going to let this in because it's not being brought in violation of 412, there was no notice requirement. This is purely cross-examination to impeach this witness. At that point, the state should have said, okay, wait a minute, we've got criminal charges that have been filed against him in Gibson County. We are now going to seek to introduce those against him in the event this comes up on cross-examination regarding the impeachment issue, since the court's ruled on the 412 question. And at that juncture, we are then in a position to respond how that needs to be addressed or dealt with. More importantly, Judge Parrish can then tailor his ruling based upon the testimony presented at the jury out hearing as to whether or not that was relevant, whether or not 403 was violated, and if 404B, in fact, did allow that to take place, because that puts us on a whole new level. And I would submit to the court that's where the error occurred. The question that brought all this on can be found at page 15 of the brief. And it says, quote unquote, and this was the question that the state's attorney asked this witness, question, to your knowledge, have rape charges been brought against the defendant in Gibson County? Where in heaven's name did that just come from? So there obviously is, at that point, that's when we became aware they were going to attempt to use the criminal charges against Mr. Barker, and that's where they crossed the line. The judge, even at that point, had the jury step out, but the question had already even been asked at that point. And the jury heard that question, because you see in the analogy that Judge Parrish says we're going to have the jury step out now. So I would submit to the court that due to what it was presented for, it was not an invite to bring on that type of a counter to what was clearly impeachable material.
One last question, real quick.
Yes, sir.
Mr. Camp. So I know you said yes before, but I haven't seen it, and maybe I just missed it in either brief. The trial court's limiting instruction.
Your Honor, I will say, and I think that the state attorney did bring that out, the jury instructions were not made part of the record. I know it was addressed in a jury conference, and I do recall vividly from my having been there that the court did instruct that jury to, in fact, say that any issues regarding prior charges. So I will tell the court that instruction, as Your Honor stated, was, in fact, given to the jury, and I do have specific.
It's not in the record.
It is not in this record. No, it is not, and I believe that's right. Thank you.
Thank you.
Yes, sir.
With that, we are going to take a short recess, switch the judge out, and we'll be right back.
All right.